Brothers and sisters, to break the grip of corruption and black money, we have decided that the 500 rupee and 1000 rupee currency notes presently in use will no longer be legal tender from midnight to night, that is 8th November 2016.
Brothers and sisters, to break the grip of corruption and black money, we have decided that the 500 rupee and 1000 rupee currency notes currently in use will no longer be legal tender from midnight tonight. These were the words that Prime Minister Narendra Modi used to announce demonetization in a televised address to the nation at 8 p.m. on Tuesday, 8th November 2016. 6 years later, this Monday, a Supreme Court bench of 5 judges upheld by 4:1 majority the Modi government's November 2016 decision to ban Rs 500 and Rs 1000 currency notes. The 5-judge bench comprised of Justices S. Abdul Nazir, B.R. Gavai, A.S. Bopanna, V. Ramasubramanian and B.V. Nagaratna. The majority judgment was authored by Justice Gavai, while the sole dissenting judge, Justice Nagaratna, differed with the majority view. And the main point of difference between the majority and the minority judgment was a provision of the Reserve Bank of India Act. I'm talking about Section 26(2) of the Act. What does this provision say, and how did the majority and minority judgments differ on their interpretation of the law? I'll explain to you in this video. Now, to begin with, Section 26 of the RBI Act talks about legal tender character of notes. Section 26 subclause 1 essentially characterizes all banknotes as legal tender, which in simple terms means a coin or a banknote which can be legally tendered or given for discharging any debt or meeting any financial obligation. Section 26(2) essentially allows the central government to declare that any series of any banknotes of any denomination shall cease to be legal tender after a recommendation from the Central Board of RBI. You can see the provision on your screens right now. The notification issued by the central government on 8th November 2016 demonetizing the notes was essentially issued under Section 26(2) of the Act, and so naturally this was the point of contention before the Supreme Court. With regard to this provision, the bench was considering whether the power available to the central government under Section 26(2) means that it can be exercised only for one or some series of banknotes and not all series of banknotes. The court was also facing questions on the legality of the decision-making process while issuing the demonetization notification. Now, why did it need to look into such a contention? Basically because the petitioners had argued that all series of banknotes of Rs 500 and 1000 could not have been demonetized by a stroke of a pen. They said that the expression any in Section 26(2) of the Act means a particular series of a particular denomination of a banknote and not all series of all denominations. But the majority judgment held that the power available to the central government under Section 26(2) can be exercised for all series of banknotes. The majority verdict advocated for what we call a purposive interpretation of the provision. This essentially means that an interpretation which advances the purpose of the Act and which ensures its smooth and harmonious working must be chosen, and not the interpretation which leads to absurdity or confusion or contradiction between its various provisions. So basically it gave an example as well. It said that, for example, and I quote, if there are 20 series of a particular denomination and if the argument of the petitioners is to be accepted, the central government would be empowered to demonetize 19 series of a particular denomination, leaving one series of the said denomination to continue to be a legal tender, which would lead to a chaotic situation, unquote. Now, on the validity of Section 26 subclause 2, the petitioners had also submitted that if the word any is not given a restricted meaning and it is meant to be all, then the provision should be struck down as it gives unguided and arbitrary powers to the central government. However, the majority verdict upheld the provision, observing that it does not amount to conferring excessive delegation of the powers on the centre. The majority verdict also pointed out that the two requirements under Section 26(2) are, you can see them on your screens right now. Firstly, recommendation by the central board, and secondly, the decision by the central government. The majority verdict then asserted that the RBI, while making the recommendation, and the central government, while taking the decision, have taken into account and taken into consideration all the relevant factors. It also interpreted the word recommendation in Section 26(2) to mean a consultative process between the central board and the central government. It then noted that the RBI and the central government were in consultation with each other for a period of 6 months before the notification was issued, and therefore it cannot be said that there was no conscious or effective or meaningful or purposeful consultation between them. On the other hand, Justice Nagaratna began by observing that the majority verdict does not recognize the fact that the RBI Act does not envisage initiation of demonetization of banknotes by the central government. She asserted that Section 26(2) only contemplates demonetization at the instance of the Central Board of the Reserve Bank of India. That is, it should be initiated by the RBI. However, since in this case the proposal was not initiated by the RBI, the demonetization exercise could have been undertaken by the central government only through an ordinance or a parliamentary law. As against the majority verdict, Justice Nagaratna also favored giving the provision plain grammatical meaning and not a broad meaning. She said that if the word any is not given a plain grammatical meaning and interpreted to mean all series of banknotes of all denominations, it would vest with the central government of the bank unguided and unlimited powers. She said that this would be arbitrary and unconstitutional, as this would amount to excessive vesting of powers with the bank. Therefore, in order to save the provision from being declared unconstitutional, she read down the meaning of the provision to say that the RBI can initiate a proposal for demonetization under Section 26(2) only for a particular series of banknotes of any denomination. With the same understanding, she also ruled that when the RBI recommends demonetization, it is only for a particular series of banknotes of a particular denomination. She further said that the recommendation under Section 26(2) in this case did not originate from the RBI and was obtained from the bank, and therefore it could not be considered a recommendation at all. She said that such a concurrence to a proposal originating from the central government is not akin to or similar to an original recommendation from the RBI under Section 26(2). And this is how the two opinions in the case and judges in the case differed on the language of a single provision of the RBI Act, with the majority judgment upholding the demonetization process and activity, while the minority verdict striking it down. That's all I have for you for now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.